Keith Davidson from Albertson & Davidson. In this video, I want to discuss what happens when one beneficiary sues and maybe that beneficiary wins at trial. Does that help other beneficiaries who are similarly situated? And the answer is it really depends. So there's two ways that a beneficiary can win their case. One is they take it all the way to trial, they go to trial, and they win at trial. The other way, and this is the way that happens a huge majority of the time, is that the beneficiary may litigate it, and before trial they're offered a settlement or they go to mediation and a settlement is reached in mediation. There's two very different consequences from a beneficiary winning at trial versus winning at settlement. When a beneficiary wins at trial, so for example, let's say a beneficiary is trying to overturn an amendment, and if they overturn the amendment, it rolls back to an earlier version of the trust that benefits everybody. That court win will benefit all beneficiaries because once a document's invalidated and it rolls back to an earlier document, it similarly benefits everyone. At a settlement conference, however, the beneficiary who appeared as a party in the action, the one who actually was participating in the lawsuit, and the trustee or any other party who's participating in the lawsuit, they have the right to settle and ignore the other beneficiaries if they choose to do so. Under California law, a settling beneficiary can settle only their claim or only their portion. So let's say you have a beneficiary who was supposed to get a third of the trust estate, and then an amendment came along and they were entirely disinherited, but so were two other beneficiaries. Well, if only the one beneficiary sues, and if that case goes to mediation and settles, that one beneficiary can settle on their 1/3 share of the trust. They can get some portion of that 1/3, and the other two beneficiaries can simply be ignored or cut out. That may seem unfair that one beneficiary can get their share and the other two beneficiaries who are similarly situated would get nothing. But under the eyes of the law, it's the people who come forward and participate in the lawsuit who have the right to settle that lawsuit on any terms they like. And that's why if you are a disinherited beneficiary and if you do want to pursue your claims, you need to appear and become a party to the lawsuit. Now that doesn't necessarily mean that you have to do a lot of work. Maybe there's another beneficiary that's doing all the work, but you should at least join the lawsuit and become a party, because if you don't, then everybody else can settle and they can ignore you and they can ignore your interests. Now keep in mind that 95% of civil lawsuits, and that includes trust and will lawsuits, settle before going to trial. So that means a huge majority of cases are going to settle before going to trial. And that means if you're a trust beneficiary and you're worried about getting a share of the estate, then you really need to appear as a party in the lawsuit so that nobody can settle without you being involved and without you having a voice and having a say in what the resolution is.
Albertson & Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for our complete library of helpful legal videos and articles from your favorite California trust and will litigation law firm, Albertson & Davidson, LLP.